discussion on the framework that we'll refer back to in terms of the inquiry. So unless anyone's got any other queries, we can probably move on. But any queries from anyone? No, I don't see any hands up, so that's useful. Item 4 on the agenda, I had labelled that additional information, EIA. This is the point that I'll be asking the applicant, first of all, just to kind of highlight their plans for the publication of additional information, because I do believe that it's at least two pieces of, or two topic areas that are to be covered by additional information. In particular, it would be useful to confirm timescales and any proposals that you do have around that. I believe it's to do with flood risk and access, and then the cumulative baseline around landscape and visual impacts. But if I can hand over to the applicant just to kind of run us through your proposed schedule.
Thank you, sir. Yes, there are a number of items of additional information which the applicant is proposing to publish. The first of those is that we are considering the need for any update to the cumulative landscape and visual impact assessment. The current view is that there may not be much required by way of an update, sir, but I would like to propose that the applicant writes within a period of time, say for example 2 weeks, to confirm exactly what updates it proposes to include in that update, so that there is a measure of agreement, hopefully with the other parties, about what needs to be included in any update. There are certain other items of landscape and visual material that may also need to be produced. I think there is a request for some new photography from certain viewpoints, which can be produced subject to weather conditions, something that will have an impact on when those items can be produced. But the main piece of landscape and visual impact evidence will be an update to the extent required of the cumulative landscape and visual impact assessment. Separately, as you mentioned, there is an updated flood risk assessment, which we propose to publish. That has already been circulated, at least to SEPA, and I believe the other parties may have seen it as well, but certainly SEPA has seen it and has indicated that it is likely to withdraw its objection once that material is published. So we intend to include that with the AI, package of AI. And then there is the last item is the clarification report of March 2025, February 2025, I beg your pardon, which I see on the agenda. So our view in relation to that document is that whilst we took the view that it was in the nature of a clarification document rather than anything which introduced new environmental information, we are comfortable with it being included in the AI. Since we're going to be advertising information in any event, then we would be content that that is included in the package. The only slight concern which I have with that, sir, is that as part of that clarification document, there is an earlier version of the flood risk assessment, which is incorporated in that document. That's now been superseded by the document which we're proposing to publish, which has addressed the comments from SEPA and others. So there is a possibility of some confusion, but I think we'd propose to address that simply by including a clarification covering letter or a page within the document that explains that that is an earlier version of the flood risk assessment, and it should be treated as superseded by the most recent version. Aside from that issue, we're content to include that document in the package of AI. That's it so far as the scope is concerned. So in terms of timing, I understand that we would be in a position to publish all of that information by the end of March. The only exception to that may be updated photography from certain viewpoints, because that's dependent on weather conditions on site. But that updated photography, I don't believe requires to be included as part of the AI. That's more in the nature of evidence or updating of photography at the request of Highland Council. So I don't think that needs to hold up the publication of the main body of AI, which, as I say, we should be in a position to provide or publish by the end of March. I would also just mention that I think a number of these matters, including the clarification report, have been seen by the other inquiry parties already. So there's nothing in there that is going to be a surprise or that is new. And I say that because I think it's relevant to the impact that this timetable will have on the earliest inquiry dates that we could fix. So that's the applicant's position on AI. So.
Okay, thank you for that. So that publishing at the end of March, so the consultation in theory could be throughout April, and the consultation exercise could be concluded after that. In terms of is there any comment on what you've heard there? Let's leave the clarification report for just now, but does anyone have any comment on the timing of the additional information? I would like a separate discussion just on the need, if there is a need to publish the clarifications report, but anything on the timing of the additional information from the council's point of view?
No, nothing on time.
Okay. Normally, if additional information is to be published and it's relevant to further procedures and topic areas within an inquiry, then cases may be sisted until such time as that is carried out. In this case, it may well be that depending upon what we discuss or what we agree later on, is that we could potentially run these elements in parallel, given that there may not be that much crossover between the topics that might be subject to procedure and topics that will be either dealt with further written submissions or there's enough information. So does the applicant have a view on whether or not they have thought through the implications of the case being sisted, or do you have a firm view that it can run in parallel?
We have a firm view that it can run in parallel, sir, and for the reasons you've just given, which are that the first item is really an updating of, and it may be a very brief update of any landscape and visual impact material, and given the council's withdrawal of its objection on this topic, it remains to be seen what further procedure, if any, is required on that topic. But it seems, and without jumping ahead on the agenda too much, it seems unlikely that we're going to require oral process on this topic. So there is little in the way. This is really a formality, sir, to ensure you have the most up-to-date information. I think the same is true of the flood risk assessment again, which, in the event that SEPA withdraws its objection, which it has indicated that it is likely to, again, I think it seems to me that we are unlikely to need further procedure of any sort on flood risk unless the council thinks otherwise. But it's difficult to see on what basis we would need that in the event that SEPA withdraws its objection. So I think this is a case where really this is a formal step that's required to ensure that information's been dealt with appropriately, but it should in no way has a bearing on the substance of the matters really to be dealt with, other than perhaps reducing the scope of further evidence that's required. So I would suggest that, yes, this is a case where these procedures should run in parallel.
Does anyone have any views on that just now, or do you want to return to that? I'm comfortable to move forward on that basis at the moment, unless there is anything that comes through the discussion on procedures later. I don't see anyone raising hands or getting too excited about that, so that's useful. Quick discussion on the clarifications report. I highlighted that in the agenda. as far as I can see, I don't think the ECU picked that up as additional information. It wasn't presented as additional information, but there were a number of matters in that report which you could look at as additional information. I haven't formed a firm view yet, but the updated flood risk assessment, I think the applicants highlighted that. There's additional, designs and mitigation put in there. There was also additional analysis from a peatland point of view, and some revised visualizations. Now, importantly, not all have been additional information, but had the council given some thought to that at all, or is that something you turned your mind to at all in considering the information on this case?
As far as I'm aware, it's not been a matter of concern to us, the additional report. And I mean, I'm generally content. My understanding is we're generally content that we deal with it the way that Mr. Gillies has outlined. And I agree with him that in terms of the flood risk, that we're obviously reserving our position, but that our objection on that basis may well go in due course. But I'll deal with the other two bases of rejection in due course. But in terms of that document, we're content that it's dealt with in the way Mr. Gillies suggested.
Any of the other parties? I've viewed it. Based on that, I would be content if it was advertised as part of the package. Don't think there's necessarily a need to separate out these elements that I've highlighted. I think it would mean that we don't need to come to a decision on whether or not it has to be advertised further down the road if I look into it more, or if others look into it. I think it would be a pragmatic approach just to advertise that as the additional information as you put forward, and that safeguards that information with regard to the EIA regulations. So I'm content that we move forward on that basis. Okay. I'll bear in mind those deadlines or these timescales when we come on to the further procedures, which is what we're about to talk about now, item 5. Before I start to go through each of the thoughts on further procedures, I think it's useful just to flag up in writing our reports, we'll take account of all environmental information, any submissions made, including those from the Community Council and others, before completing our reports. So just because a topic area or a subject hasn't been subject to further procedure, it doesn't mean it doesn't feature or won't feature in our reports. The areas that we agree that require further procedure are those that just need to be kind of teased out a bit further, and that's why I've set out my initial thoughts in Annex A. So hopefully that is useful from the Community Council's point of view, is that any comments that are made are taken on board, whether or not they're subject to further procedure or not. So if you could turn to Annex A of the agenda, and that sets out a table at the start and then some notes. These were preliminary thoughts. My thoughts have changed a little bit since those have been issued, because a few things have come in. Originally, I had thought we would have to request the council's case because we had 3 grounds of objection, but not, if you like, the case. But that has now been submitted, and it might be useful just to have a discussion on how we would now deal with that submission. I'd be interested to hear the applicant's view on that, but we do have the council's case now. Has the applicant got any particular thoughts on if there is any requirement on the back of that submission? I would certainly be expecting that you'd be given, if you like, a right to reply to the committee report and some of the information that's in there that might not be subject to the oral procedures. But has the applicant given any thought to how we would just treat that case, given it's coming in quite late at an unusual time?
Thank you, sir. I think we would be content to the extent necessary to respond to the committee report in writing within a short period of time. So I think the other substantive aspects of the council's case on its remaining 2 reasons for objection, I think we would expect to be brought forward in the usual way, depending on the procedures that are adopted for those topics. Now, I did note Mr. Finlay said about the potential position in relation to reason for objection 3 on flood risk, but I think I'm content that we have a discussion about what the processes are for the remaining topics, and I think it would be helpful at least to have the opportunity, if need be, to say anything in writing in response to the committee report that's not swept up in the discussion about further procedure.
So you'd be content with that being dealt with by further written submissions, and I would give the opportunity for that to happen. From the council's point of view, does that seem like a reasonable way forward for giving the opportunity for the applicant to respond to any matters that aren't covered by the major procedures, if you like?
Yes, but perhaps I can just whether the applicant considers it necessary to do so will obviously be a matter for the applicant. There are now 2 reasons for objection. One is the peatland habitat, and our case on that is primarily mirroring the case of or taking the case from Nature Scott, and indeed we were going to propose to you and in due course that we needn't attend whatever or take part in any session that you arrange to deal with that, because Nature Scott will, and there's no point to have duplication of evidence. And indeed our objection on that basis effectively relies on Nature Scott. In terms of the flood risk, as Mr. Gillies has just pointed out, it may well be that ground of objection goes when we are see what SEPA says and consider the new material. So it may be that there is very little for Mr. Gillies to client to respond to, but generally I don't object to him having the ability to respond in writing insofar as he needs to do so, but that may assist you and him in setting out what the Highland Council's position is on the remaining grounds of objection.
Now, it was also to give the opportunity, if there was anything else beyond the grounds on landscape and visual matters, if there was anything to respond to or pick up on. It may not be substantive, but it might be information that they might wish to pass to me. So
absolutely, I have no objection to that. There may be other bits that may concern conditions in due course, which they may want to respond to, but that's obviously a matter for Mr. Gillies and his client.
I mean, since we touched there upon flood risk management, you'll see it's ticked in the written submissions. Essentially, I was anticipating that the applicant we'd advertise the additional information and we'd get responses back. I would formally ask SEPA and the council to respond to that, so that it's part of the inquiry procedures. So we'd be asking for you to respond to that, and then allow the applicant the opportunity to respond back. And that was what that X in the box was, essentially ensuring that I asked the council and SEPA to respond to that additional information and to set out their position and to allow the applicant the opportunity to respond. So if everyone is content with that element, then we don't necessarily need to discuss that bit further. Does that sound reasonable to the applicant?
Yes, sir, that does. Thank you.
And from the council's point of view?
Yeah, absolutely so. And we're all anticipating at the moment that grant is going to disappear. I suppose that's just an outside risk. It might not do, but that can be raised in any written submission. So we're entirely satisfied with your proposed procedure for that.
Is anyone else concerned about the procedures for the flood risk management matters that we've just discussed? No, I don't see anyone throwing their hands up in the air. In terms of policy, then, generally speaking, I'm not convinced that there is a need for further oral procedures. What I would propose is that energy policy, planning policy is dealt with through a statement of agreed matters or statement of agreement led by the applicant, covering a scope that I would set out in the note of the meeting, essentially to highlight areas of agreement across policy areas. And there may be a small number of policy areas where there is disagreement based on the information so far. But that's how I was proposing to deal with it, and ask the applicant to lead on that matter, rather than holding a policy hearing. The matters that I would expect, to be in that is, to probably talk about energy policy, how it relates to Schedule 9 of the Act, Scottish Government policy across energy and planning, and any other relevant guidance, and probably include the economic benefits of the proposal, and try to get as much alignment as is possible between the three main parties, between Nature Scott, the council, and the applicant, although perhaps Nature Scott's contribution that would be less than the council's. But does that seem a reasonable approach to just maybe provided with the relevant policy, how the proposal sits against that policy, and any areas of disagreement? Maybe turn to the applicant first.
Thank you, sir. Yes, that does seem entirely sensible to the applicant. We are content to produce a first draft statement of agreed matters and to lead on that, and we can do so quite quickly. And it does seem to us that we ought to be able to agree the vast majority of policy issues, leaving hopefully only a small number of matters requiring any further written submissions on this topic. One other point I would say, sir, just on the question of Nature Scott as well, is that I think it would be our suggestion, and I will come on to this no doubt when we discuss the peatland habitat topic, but I would be proposing that we enter into a separate statement of agreed matters so far as possible with Nature Scott to narrow down the scope of any areas of disagreement on those technical matters, but I'm sure we'll come on to that when we get onto that topic.
That's excellent, because that's exactly what I have got written down in my notes here as well. So that's useful that I'm getting your thoughts on that. From the council's point of view, in terms of being able to contribute to an energy policy paper, highlighting the relevant policies that I'm to consider and all the areas of agreement. Does that sound reasonable rather than any further procedure beyond that?
Entirely reasonable. I mean, we've got considerable experience of debating policy insofar as, and the debate tends to be very limited indeed. And given that it's likely to be peak matters, between the council and the it may well be that there will be agreement as to the approach, and I entirely agree that it's appropriate that Nature Scott are involved in that. But yes, written submissions should be entirely appropriate.
Did Nature Scott have anything to add?
Nature's got perfectly happy to engage in written submissions on policy, although the scope for the proposed hearing session also, as well as addressing impacts that is currently proposed to address policy. Is it your intention, sir, to use that as, in effect, if matters aren't addressed through the statements of agreed matters, if there are unresolved policy issues, then those policy issues would be discussed, at least on your provisional view, in the combined hearing session?
If there are, perhaps if I expand on what I said in response to the applicant on, if you like, a separate peatland a statement of agreement, I think that would be useful. If Nature Scott, the council, and the applicant were to prepare a separate or a subsection of that, probably a separate statement of agreed matters on peatland matters, which would cover policy matters specific to and guidance matters specific to that relevant topic, to highlight the areas of agreement and use that document in a sense to set out the scope for any hearing or inquiry. And that's how my thinking has developed. It's not exactly how it's expressed in the annex, but having thought it through a little bit more, I think if we had agreement that a statement of agreed matters on peatland habitat was prepared, that would really be able to focus down and define quite clearly what the scope would be for that oral session, if we do agree on oral session. So that draft scope that I've set out, the draft scope for peatland habitats hearing session, that would be, if you like, refined and given a bit more detail if we go through an exercise of a statement of agreed matters. Does that sound reasonable to Nature Scott? Does that?
It does indeed, and this I think will tie in nicely with the applicant's proposed a joint site visit by its expert witnesses and Nature Scott's witness, and arrangements are being made on that front. So the statement has at least the potential to cover factual matters as well as policy issues.
As far as the council is concerned, specifically dealing with peatland matters, it does the preparation of a statement of agreed matters in order to really define the scope for any further procedure. Does that sound like a reasonable way forward? I would probably ask the applicant again to lead that in the first instance, but contributions from Nature Scott and the council. Does that sound reasonable to the council?
Yes.
And from the applicant's point of view, does that sound like a basis in which we can move forward on the initial written submissions on peatland habitats?
Yes, it does, sir. That sounds very sensible.
And what I would hope that would do is like improve my draft scope of the further procedure, whatever we agree, and will allow it really to kind of hone down on the key matters. Since we are talking about that subject, where there's differences of opinion in terms of what oral procedure. I think there's probably, I would guess, a view that it does require an oral procedure. I had it marked down as a hearing. I think that applicant, from memory, were keen for an inquiry. I think Nature Scott felt that the Peatland Habitat matters could be dealt with by a hearing. Does the council have any particular view on oral proceedings? I don't think we've had that yet for Peatland Habitats.
No is the answer to that. I think I indicated that the council at the moment is considering possibly only having a watching brief, if any involvement in the hearing on peat, because it doesn't have anything additional to add to what Nature Scott may produce. So we're quite content that the decision on what form of procedure is appropriate is primarily between Nature Scott and the applicant.
Okay, thank you for that. From the applicant's point of view, did a hearing process as is preferred by Nature Scott, have you given that any further consideration?
Thank you, sir. Yes, we have. I think the applicant's position remains quite firmly that an inquiry session ought to be fixed at this stage. And I say so, the reasons for that, sir, are that whilst it is indeed the case that we are hopeful of being able to agree as much as possible with Nature Scott, and as Mr. Ferguson has said, there is a proposal to carry out a joint site visit, and we're the applicant and Nature Scott, I think, are hopeful that that will lead to a measure of agreement, and that process, together with the process of agreeing a statement of agreed matters, which we've just discussed, may well narrow the scope of matters. But as they stand at the moment, as matters stand at the moment, so there is quite a difference of opinion on potentially quite technical matters. And it remains the applicant's position that the best way to explore that and to draw out the evidence to assist you in preparing your report is for that evidence to be subject to examination in an inquiry session. I would say that we do not think that is going to have any implications for the length of time required. I think our view, and no doubt we'll talk about timetabling shortly, but our view would be that a day or a day and a half at most would require to be set aside. I think that would be the case where we're dealing with a hearing session. So I don't think that in terms of considerations of efficiency of process or proportionality that really there is much difference in terms of timetabling. But I think the nature of an inquiry session is merited, or an inquiry session is merited in this case because of the technical evidence. Now, one way of approaching it, sir, may be to fix an inquiry session which, if in the event that we are able to substantively agree matters, could be downgraded to a hearing session at a later date in the process once it becomes clear what is actually left to be discussed. And that would allow at least provisional inquiry dates to be fixed, with the possibility of that being converted into a hearing session, or indeed further written submissions if we get to the point of substantive agreement with Nature Scott. We just don't know whether that is going to be the case or not at the moment, sir. So be mindful of the provisions and the procedures that we're operating under. The applicant's request is for an inquiry session on this topic.
Mr. Ferguson, from Nature Scott's point of view, you have anything to respond to there? You noted hearing. I'd indicated a hearing, but I was keen to hear what the parties had to say today and to be persuaded one way or the other. But Mr. Ferguson.
Nature Scott continues to believe that a hearing session would be the best form of oral session in this case. There is guidance in its guidance note 8 which is an older guidance note from 2014, but it does include some useful guidance as to the sorts of issues which are best addressed through hearing sessions and inquiry sessions. And looking at the key points of difference, the first point of difference is regarding the ecological condition of the peatland. And these are largely differences in professional judgments. They're not factual disagreements, which would require cross-examination. There's also a disagreement regarding and differences in the survey methodology. And again, those differences are exactly the sort of matter which, as per the guidance note 8, indicates could be addressed in a hearing session. These are differences of a professional opinion. Similarly, with the application of the SSI selection criteria, another relevant factor there is your suggestion that there be a combined session dealing with both the impacts as well as policy and conditions on the related peats management plan. If impacts were to be stripped out and dealt with in an inquiry session, we would lose the functional connection between those elements. Whereas a combined, it would be very rare for there to be an inquiry session dealing with conditions or indeed policy these days. So in Nature Scott's view, a combined hearing session dealing with impact, policy, guidance, conditions and the related peats management plan would be the best way forward.
Do you have any concern with regard to timetabling and scheduling with regard to whether we choose to have a hearing or an inquiry session? Does that do you think that would impact availability or timetabling issues or
it would affect earlier dates, and you referred, sir, to dates proposed for, I think, the first 2 weeks in June. So there inevitably with an inquiry session, the preparation is of a different character to prep for a hearing session, and we've looked carefully at the availability of the Nature Scott witness. So it would affect timetabling if we were looking at an earlier oral session, whereas if it was if the oral session was later in the year, it's neutral in terms of preparation and availability.
so is that earlier than the June
It's
proposal?
There would be a difficulty for Nature Scott in participating in any oral sessions the first 2 weeks in June. I did respond to Mr. Gillis on that, and I do have a note of Nature Scott's availability for the following weeks and indeed months.
I've heard what you've both said, and if we can, for the moment, try to schedule in oral process, because I think there's agreement on that, and we can put it down as an inquiry stroke hearing at the moment, and that a determination on that be made once that a statement of agreed matters and a defined scope for oral process comes out of that. Would it be suitable to leave, if you like, the final decision until that time, or would you be uneasy with that? Maybe the applicant first.
I think we just need to be careful to allow time for everything that flows backwards from an inquiry session.
Yeah.
So that's my only concern. The decision needs to be made in time to allow preparation for both parties to start in advance of that. I do have something to say in response to Mr. Ferguson on diaries, dates and availability, sir, but I'll wait until we get to that point in the agenda.
we'll come on to that. Mr. Ferguson, on the point of a final decision on the nature of the oral process, would it be too late to leave it until the statement of agreed matters is prepared?
I think it would, sir. I think it would be better to fix the procedure one way or the other at this stage.
Well, at the moment, I think from what I've heard, I'm probably persuaded that we mark it down for an inquiry at the moment, with the proviso that if there is agreement further down the line that a hearing would be better, then we would do that. I'll also give consideration to whether or not elements with regard to planning conditions, if they are to be discussed, should be dealt with by a separate procedure, whether it's further written submissions or a hearing on conditions, because I think discussing draft conditions in an inquiry is not going to be that appropriate. So I think we'll take it forward on that basis, and I'll also reflect on that further before I finally prepare the note of the meeting, which will be more definitive. But I think that's where I am at the moment. Mr. Ferguson, you've got
Yes, sir. Just one final thought on this before you make your final decision. We have had experience in recent years of what you might term hearing sessions plus, where the opportunity is given to parties to ask questions through the reporter. And if you were of a mind to have a hearing session, Nature Scott would be happy to allow that element of the session to be used to the maximum possibility. So that
do you have any thoughts on that for the applicant based on your experience?
I think your position remains so that we think an inquiry session would be appropriate. I hear what Mr. Ferguson says about flexibility in the way a hearing session is conducted, but it remains a hearing session without formal cross-examination of witnesses and so on. And the reasons for requesting an inquiry session, I think, remain.
Mr. Ferguson, I think you have your hand up again. All right, okay, that's fine. Well, I've given you my thoughts on the matter after hearing what you've said today. I'll also give that further consideration before preparing the note, but I'll make that clear when you prepare the note. Is there anything else to discuss on peatland habitat? I think I did hear that there was a joint site inspection being planned. Do you? I'm not asking for an invite, but is that something that you're inviting the reporter to, or is that something that you see as part of preparing your statement of agreement? If that's part of your process to get to a conclusion on where the areas of disagreement are, then I'm happy that you continue to do that. But any thoughts from either Nature Scott or the applicant on that?
Yes, thank you, sir. For me, it is. I think the purpose, as far as we see it, and I think Mr. Ferguson is in agreement with me about this, but the purpose, as we see it, is to allow the parties to have an open and constructive discussion on site, with a view to establishing what can and can't be agreed as part of preparation. So I think clearly you'll want to visit the site yourself at some point as well. Whether that needs to be accompanied or not is maybe for discussion, but I think perhaps this site visit is more appropriately kept between the two parties. And there's not going to be any representation of the parties at that site visit either. It's purely their experts, sir, who are going to be on site.
That sounds reasonable to me. Mr. Ferguson, is that your understanding?
I would agree with Mr. Gillis that it's primarily for the parties. We do though have a view as to whether your own site visit should be accompanied or not.
Well, I had planned an unaccompanied familiarisation, a site visit, but since you've raised it, I'm quite happy just to discuss it just now. Do you feel that there is a need for, as part of the inquiry process, for a specific site a visit to be accompanied on Peatland Habitat?
Yes, sir. As things stand, at least it may be that the statements of agreed matters would change the thinking. But as things stand, and primarily in relation to the ecological condition of the peatland, we think it would be useful for the experts to accompany you and to point out the relevant features which support their position.
And would you anticipate that that would be around the time of the oral process?
Yes, sir. Preferably just before the oral process, but I appreciate that timetabling might not necessarily allow that. But yes, whether it's shortly before or shortly after the hearing or inquiry session would make sense.
And does the applicant have a view on that?
I haven't certainly given this any thought, sir, but in principle, I don't have any objection to that, subject to being able to timetable the session. But I agree with what Mr. Ferguson said, that the need for you to be accompanied, I think, will become clearer once we have finalised any statements of agreed matters and so on.
I'm perfectly content that we that plan for an accompanied site visit specifically on peatland habitat, not generally speaking, but specifically on that matter. And as time moves on, you can share those arrangements and timetabling if Nature Scott and the applicant are able to agree that. I would anticipate that perhaps other parties might want to attend such an accompanied site inspection. From the council's point of view, although you wouldn't be taking part in the oral sessions, does that mean that you wouldn't be taking part in the site inspection?
I think we'll reserve our position. It may be that somebody should be there, but I think if Nature Scott are there, then that side of the argument is properly represented. So at the moment, I think it's unlikely we would wish to be part of a joint site inspection, but perhaps we can reserve our position and inform you when, in response to your note of this meeting, just in case we take a different view. But I think that's likely to be our position, that we wouldn't wish to be involved in that.
And from the Community Council's point of view, I think your representation didn't go into any detail on peatland habitat, I don't think, but so from that I would assume you might not be looking to be involved in the accompanied site visit. Is that fair?
I can certainly ask and come back to you, obviously with more expert advice on peatland habitat that has come in from Nature Scott. Then it may be something that concerns the Community Council with lots of schemes, so I will
the parties who would be party to each oral procedure, but I'm going to come on to that and ask who wants to be part of things. But I just thought we would try and nail that down just now, since we were having a chat about peatland habitat.
thank you.
But unless you as a Community Council feel otherwise, I'm now of the view that there may not be a need for an oral session on landscape and visual matters. The council has withdrawn its objection on that basis. There's quite a bit of information in this committee report. the Community Council yourself have submitted some comments on landscape and visual matters. I would propose that any questions I have and all that material are dealt with by further written submissions now. So that would mean asking Community Council further views on certain things, perhaps the council or the applicant, unlikely to be Nature Scott. But I had proposed originally an inquiry session, and that was on the basis of the council mounting a case on that basis, but that's not the case now. So I would prefer, my preference would be to deal with that. Any questions I do have, and that might well be guidance on where to go and what viewpoints to prioritise and things like that, that I'd be writing out to parties on that, and not proposing an oral session on landscape and visual matters. If I could turn to the applicant first and get your views on that. That's a slight change, obviously, to what I put in the agenda.
Thank you. So yes, the applicant's content with what you propose in relation to landscape and visual matters.
And the Community Council's point of view, does that sound reasonable, that if you're given an opportunity to reply to landscape and visual matters on the basis of the questions that I would be asking?
Yes.
Yes. Sorry, sir.
Sorry, I thought you were talking to the community. You said the council. I thought you said the Community Council.
No, I said Community Council. I thought I said Community Council, but I'm now going to ask the council if they'd be quite happy for landscape and visual matters to be dealt with, obviously, by site visits, unaccompanied site visits, but also informed by further written submissions, and those two elements to be the procedures for landscape and visual matters for this case, Mr. Finlay.
Yes, we would be, and I think it's unlikely we'll be making further written submissions, but yes, that seems entirely appropriate.
You may have a few questions. I think the applicant has indicated that there was a request for further material and such like, and I've got to consider that, and I may ask that for the purpose of the inquiry. I may not, but I would clarify that in further written submissions. Just to highlight as well that I would be setting out those further written submission requests in the note of the meeting. So after the meeting, I'll go away and give it serious consideration and set out as many of the further written submission requests as I can. So that's just a flag to perhaps the Community Council that when the note comes out, you will see the requests that I set out, probably in an appendix for further written submissions. So keep an eye out for that.
Thank you.
In terms of conditions, you'll see what I set out there. There was a little paragraph on draft conditions. Was keen to allow the applicant to negotiate or discuss, if you like, liaise with the council and perhaps others, and come to a draft set of conditions based on the ECU standard conditions, highlighting any places that there is disagreement. If ministers were inclined to consent the application, that's fairly standard procedure now, I think, in terms of preparing conditions, and hold or discuss a date that maybe a half-day hearing could be held if that process suggests that there are areas of disagreement that would require an oral process. Does that sound reasonable to the applicant?
Yes, it does. That's precisely what I was going to suggest. So, and experience would suggest that there's probably unlikely to be many matters, if any, left to discuss after we've had the opportunity to discuss the conditions with the council.
From the council's point of view, does that sound reasonable to go through that process and to have a backstop of a hearing date, maybe half a day, if needs be?
Yes, we echo Mr. Gillies' hopes that such a session would not be necessary if there is disagreement on one or 2 points, it's highly likely that could be dealt with by written submission.
Yes, I should have indicated that if there were areas which I felt could be dealt with by further written submissions and not an oral process, then I think I would be taking that route, and I'll try and reflect that in the note as well. From Nature Scott's point of view, in terms of dealing with planning conditions, you may want to have an input to what draft conditions go into the report. Does that sound a reasonable process from your point of view to be involved in that?
Yes, sir, it does, though it goes back to one of the points I raised before about the session originally envisaged combined impacts as well as conditions and policy. Whereas if sir, you decide on an inquiry session, would that inquiry session be limited to peatland impacts, or would that also cover conditions, policy and guidance relevant to peatland?
I'm probably going to take a little bit more time to think that through, but I would imagine the conditions element of it should be discussed through the process dealing with conditions and a potential hearing. But I'll give that some further thought and reflect my conclusions in the note of the meeting. In terms of policy matters, I think they could be more easily, or guidance matters could be more easily dealt with in an inquiry situation, depending upon the nature of the disagreement. But conditions, I think a hearing session would be far better to discuss conditions, I think, based on experience. So I'll try and reflect all that in my note of the meeting once I've given it a bit more thought. From the Community Council's point of view, does that sound a reasonable way to draft conditions? I'm sure you're not eager to be drafting planning conditions for the case, but does that sound sensible from your point of view, that the planning conditions are drafted out between the council, the applicant, and Nature Scott?
Yes, I mean, I think they would like to maybe not be drafting them, but be involved in some sort of involvement in them. And we've had very little contact. We've not seen the applicant since April 24, so it would be good if it was going ahead to actually look at the impacts on the area, so that can be part of the conditions.
Well, taking a note of that, so hopefully I'll reflect that in the note of the meeting, is that the applicant would give you sight of the draft conditions before they're finalised, and allow you an opportunity to contribute, since you've indicated a willingness to take part in the proceedings.
Thank you.
I'll reflect that in the note. There may be other topics that we've not discussed, or any other questions that I may have with regard to further written submissions. I was going to ask about the Dell 1 consent, but the council has clarified that in its committee report, so I now know, if you like, the position on that, so I won't need to ask anything on that. I would probably write out to the Stronlairg wind farm to clarify their position, to ask a couple of questions. And there are a few matters going through the material, which I'll go through again next week, that I'll write out questions to different sort of parties. I haven't set out an exhaustive list of the questions that I'll be asking, but I don't anticipate it to be too long, but there will be a number of specific matters that I'll ask through further written submissions. And does that sound reasonable from the applicant's point of view, that I try and mop up any questions I have in further written submissions?
Yes, sir, I'm entirely content with that suggestion. Thank you.
From the council's point of view?
Yes, sir.
Yeah. And from Nature Scott and the Community Council, you're happy that you might see some requests for information, possibly not to yourselves, but to others, and you'll see them set out in the note of the meeting. Okay.
Yes, sir.
So that takes us to participation. I think we've probably almost covered it. I think you've got the impression that the community council wouldn't be taking part in the peatland habitat inquiry and presenting evidence at it. I didn't get an indication that you'd be wanting to present evidence and cross-examine, given that that hadn't been an area that you were focused on. I've also got the council's view that they would be observing rather than participating. So that leaves us with the applicant and Nature Scott. So is it fair to say that that's going to position, that's the two parties to take part in oral procedures? And but the question I would ask, is the council teaming up, if you like, with Nature Scott, or Nature Scott are going to lead their own evidence and you're just going to observe?
Nature Scott are leading their own evidence and acting independently. And the nature of observation that we undertake remains to be determined. But yes, we're not intending to take any active part, given Nature Scott's involvement.
Okay. From the applicant's point of view, from what you've heard, does that clarify things for you?
It does, sir. On the question of representation, which is also part of that question, I think, just to clarify that the applicant will be, I will be instructing Mr. Marcus Trinick, KC, for any inquiry session in due course. And
do you have any witnesses as yet? It's not essential just now, but I will be asking for these at some point. But
yeah, it's the witnesses for the applicant on the peatland habitat sessions are likely to be Kate Massey and Andy Mills. So, but we'll confirm that in due course. But that's the likely witnesses on this topic, together with, to the extent evidence is required on policy matters, Mr. Simon Herrick, who's with me at the moment.
And from Nature Scott's point of view, are you able to clarify anything just now? Again, I will be asking for that to be clarified, but if you've got anything just now, I'll take it.
Yes, sir. In relation to peatland impacts, the likely witness would be Karen Rentoul, who's Nature Scott's peatland specialist. And while Karen can address guidance in relation to peatland, it's unlikely that Karen would be best placed to deal with policy. So depending on how you decide to finalise the sessions, we will have to think further on the policy side of things.
No. We'll reflect on that further before I clarify the note and how best to kind of separate that out and deal with that. I'll try to give you as clear a direction as possible from the note that I produced. So and we discussed that participation in the site visit with regard to peatland would be Nature Scott, the applicant, myself, and in terms of a formal accompanied site inspection, and the council may wish to observe that. It would normally be the parties that were involved in the inquiry. I'm quite comfortable if the specific session, but I would be quite comfortable given the small number of parties that if the council or the community council wanted to send a representative to that, then I would certainly be comfortable with that. All the parties happy with that. The participation, if you like, in the site visit would be to Nature Scott and the council to kind of point out matters. But in terms of observing that, I'd be quite comfortable with the council and the community council observing that. All parties happy with that?
Yes.
Yeah, that seems to be us in terms of the participation, because we've only got one session essentially to talk about. In terms of I suppose it's useful to talk about if we were to have a hearing on planning conditions. In terms of the parties, I would anticipate the applicant and the council to be a party to that. Nature Scott likely, and I would imagine that would be the three main parties. Is that fair? Council and Nature Scott and the applicant to be indicated as parties to the hearing on conditions.
Yes, sir.
Yeah, and from the Community Council's point of view, is that something that you would be indicating a willingness to participate in?
Yes, as I say, I can come back and confirm who that would be, but
that's on the basis that there would be a hearing. It may well be that further submissions can deal with that. Okay. When we're talking about dates, and we've really got one session to plan for. So in theory, that should be easier than normal when we have a multitude of sessions. The applicant had suggested the first 2 weeks of June. Now let's go on the basis that it's an inquiry session. I think I heard Nature Scott saying that would be difficult, but that you had responded to Mr. Gillis on dates and availability. I've not seen that, but perhaps if I could ask the applicant to first of all just clarify whether those first 2 weeks are still their preferred or potential date.
Thank you, sir. Yes, they are. And if I may just very briefly, as you just identified, so this is a very narrowly focused inquiry, and in terms of timetable, we think a day to a day and a half, including conditions, is probably the most that's going to be required. I won't repeat, sir, what was said in the note from my colleague about the urgency of this application, given that it has a grid connection date of April 2030. So that is the reason why we are so keen, particularly keen for an earlier date in this case. So those dates in early June are suitable for us. I think I heard Mr. Ferguson say it would be difficult, but I don't think he said it would be impossible for his witness to be available for what, as you have identified, is a very narrowly focused session, which hopefully will be even more narrowly focused following the outcome of the work that we're going to do with Nature Scott. So we would be very keen on the dates in the first week in June or the second week, the one being the 8th, 9th or 10th of June. Mr. Ferguson did send further dates in July. Unfortunately, those dates are not suitable for the applicant's team, with the exception at a push sort of the 27th, 28th and 29th of July. But those are by far our least preferential dates, and I would say we have a difficulty in that Mr. Herriot is not available on those dates. Now, his availability may not be an issue so far as policy is concerned if we're dealing with that by written submissions, but to the extent that he does need to input into policy matters at any inquiry session, that would rule those dates out for Mr. Herriot. And we would be very concerned about dates being pushed out beyond July, so for the circumstances that we've already outlined here. So a very firm preference is for a date either in early June, well, in the first 2 weeks in June, as indicated previously. Thank you.
Mr. Ferguson.
Yes, sir. We did carefully consider the dates, and particularly with an inquiry session, the dates in June would be difficult, verging on impossible. The Nature Scott witness would be on holiday for 2 weeks. I'm trying to map this out, but I think that would fall when recognitions would be due.
Generally speaking, 2 weeks in advance would be the latest you'd be looking for recognitions. I wouldn't want to see them any closer to an inquiry, but
so the Nature Scott witness is unavailable from 11th to 22nd of May.
Does the 27, 28, 29, I think on July, does that suit that was, I'll see by the applicant, is not the preferred, but there's a second best, if you like.
It is
Does
the
that
second
suit-
best, sir. Sorry, sir.
Does that suit Nature Scott?
It does, sir. This was one of the weeks proposed. So I didn't copy you in your office in on the dates, but we did propose, I think it was 5 consecutive weeks from July spilling into August.
Okay. I did do some rough timetabling based on the June dates, and it was going to be reasonably tight, actually, even although we've only got one session, just to allow all the timing that is required for documents and such like, although it would have been possible. But if you're not available or not able to prepare for it, then we can't probably do anything about that. And I think if there is there's a set of dates there that both parties can make, so I would be inclined that we have it in July. But I'm just wanting to make sure that in the middle of July or towards the end of July will work for all parties. I would certainly seek to make sure that if policy matters are going to be difficult for that I make sure that I kind of exclude that, if you like, or we exclude that in the scope, so that it doesn't impact on the applicant, and there may be an ability to have an earlier hearing session with regard to planning conditions, so that it doesn't all have to wait until such time as we've dealt with that oral session. But based on what I'm hearing, I don't think we're going to be able to agree an earlier date than the end of July. Do the council or the community council have any view on that? I know you're not participating, but based on what you've heard, have you got anything to contribute?
No, but can I make one suggestion that potentially for policy and/or conditions, you might consider a virtual hearing if there are any issues for those two, and then there could be more flexibility over the date in due course. Certainly, I personally have some difficulties at the first 2 weeks in June, but that may be irrelevant in due course. But if there was to be a hearing session on either of those two, which we at the moment hope there need not be, then could I suggest that is done virtually, and then that would hopefully and a date be resolved nearer the time to do that, because if it was virtual, then it should be much easier to find a date that's suitable to all.
Well, once we had agreed or had got near agreement on dates, I was going to ask in terms of format the preference for the oral sessions. But since you've raised that, is there general agreement that if we do require an oral session on conditions in Mahaffty, that that could be dealt with virtually? That would certainly be my proposal. That would be. I see people nodding. Does that seem reasonable? And what we'll probably do is, as part of the note of the meeting, I will probably request that a date is agreed between the parties. I don't think we necessarily need to get into that just now, but I will request that to be agreed in due course. In terms of if we're going with the 27th, 28th, 29th of July, should we be allocating 2 days just now? Does that sound reasonable? And if so, do we go with the 27th and 28th? Any preference from the applicant? Is 2 days reasonable to keep aside?
Yes, sir, I think so. And I think the applicant's team has a difficulty after the 29th. So if those are the dates, I think 2 days is more than sufficient. I'd prefer that we allocated the first 2 dates of that window, just in case there's an overspill into the 29th. One other point, so I'm just conferring with my team virtually, just to confirm, and this may or may not assist matters, but I understand the applicant's team is available in the first 2 weeks in July as well. I don't think those were not dates specifically suggested by Mr. Ferguson, but if that assists or offers alternative dates, the applicant's team could be available in that window as well.
Mr. Ferguson? Additional window that's now been open for you.
I would need to double check that with the team. The dates I set out starting on the 13th of July were the dates we did canvass availability during the week. So I don't know if there are specific challenges with those dates, but I only specifically considered the 2 weeks proposed by Mr. Gillis initially, and the other dates were the dates when the team were available.
Well, I had indicated that I would probably have a little break between items 7 and 8. So during that little break that I'm going to suggest, would it be possible, do you think, to try and see if you could connect with people to see if there was availability there? Is that a possibility?
I'll certainly try to do so, sir. Although the key witness for Nature Scott, Karen Rentoul, I was not available to attend today's so I may have some difficulty contacting her. But I'll do what I can during the break to see if I can get an answer one way or another.
Well, I'm going to do my scheduling during the break on the basis of the 27th and 28th, but you might come back with something else after a little bit of break. One final question, I think, on that is whether or not you feel we've agreed to be an on-site accompanied site inspection, but do you have any preference for a virtual or in-person inquiry? Applicant, first of all. Open to both.
Our preference would be for an in-person inquiry, sir.
Would that provide any difficulty with regard to the timing that we're discussing? Extra travel around that time?
No, I don't think it would, sir. On the dates, the later dates in July, that would be another reason why we'd prefer the 27th and 28th, which was allowing for travel on the 29th if necessary.
So Ferguson, do you have a view?
So I think an in-person, if it's an inquiry session, an in-person would be appropriate, and it may offer an opportunity to tie in with an accompanied site inspection.
Well, we have run fairly successful virtual inquiries, but I'm persuaded by you both. So we'll agree it would be in person, and we'll have a little bit of discussion potentially with the council, maybe others, on a venue, unless anyone has had some foresight and has thought about a venue. But if not, we can leave that until a later date. But unless a venue has been pre-considered, that would be a matter for our case officer just to discuss with the parties and identify a suitable a location. There is the opportunity, if the venues locally are not available, is that we do have a venue at our headquarters in Falkirk, but that might not be suitable given that we're talking about a site inspection. So we'll probably be led by the parties as to the most suitable venue. Anyone got any suggestions on venue? Or are you quite happy that we leave that until a later date? We will have to obviously book it in whatever in a fairly quick order, given it's the middle of summer in the Highlands. So, Ms. Ferguson.
Yeah, there is a venue in Whitebridge, just a mile along the road from the site, or the site access, if that has already been deemed suitable for another public inquiry. So that's a possibility.
Would you be kind enough to just to email our case officer, the person who's been communicating with you? That would be really useful.
Yep,
Sorry,
no
I heard someone else there.
Sorry, sir. Just to add to that, options for the inquiry, sir. The Lovett Hotel has been used for several inquiries in the vicinity recently as well, and that's a suitable venue as well that might be considered.
Okay. So we have some ideas and venues. That's great. Okay, I think that's probably everything I need to discuss before I have a short break. I'll come back, and what we'll discuss is a timeline for the submission of documents and all the things that we've been talking about. I'll try to put some dates together. I'm not going to share my screen and commit to any of the dates, but I'll orally set them out and get your impression on that, and then I'll clarify them in my note that'll be sent out sort of next week. So would we come back at 10 to 12? Is that okay? I can't see us being much longer than maybe another 10 minutes after that. But before we do have a break, were any of the other parties going to raise matters under other relevant matters? If so, is there any warnings that you want to give me just now? Is there anything that I need to prepare for? Curveballs being served. If so, if you let me know just now. I've got a couple of matters. One about DPA resources, and the second about a recent judgment that came out this week. I'll discuss those later. But were any of the parties going to flag up anything to me under item 11? Any other relevant matters? No, it doesn't look like it.
No, you're going to deal with the recent decision anyway, so that's fine.
Yes, the decision that was issued on the 17th. I'm sure some of the parties here will be aware of that anyway. But I'll go into that in a little bit more detail. Okay, so you can stay on. Just put yourself on mute, switch off the camera, and if you join back in at 10 to 12, that would be good. That would be excellent. Thank you. Are all the parties ready to go again for a few more minutes as we discuss timing? I don't see everyone quite yet. Maybe wait till Ferguson from the Community Council appears on screen. There we go. Okay. I have some draft dates now. I will obviously clarify these based on any feedback I get from you just now. I'll clarify them in the note of the meeting, but they're given just now just to see if they're reasonable at the moment. In terms of further written submissions, I indicated that they, or some of them, would be set out in the note of the meeting. So that would be Friday the 27th, with a fortnight to submit information, and then that first batch of further written submissions would close around the end of March, to 27th of March. So allowing a month for any questions. In terms of the statement of agreement, we've highlighted that there may be two, one dealing with policy, energy, benefits matters, and one specifically dealing with peatland impact and guidance. I was indicating that the 10th of April was the date that I plucked out for a submission of those. In terms of statement agreement and coming to that, does that fit in with your timetabling around the site inspection on peatland? If that's a question, before I go into other dates, does that sound reasonable with regard to getting to a position on the peatland impact? And perhaps if I could ask the applicant and Nature Scott that, April the 10th, to produce a statement agreement, does that seem reasonable? The applicant.
Thank you, sir. We haven't yet got to the stage with Nature Scott of agreeing a date for the site visit, and my instinct is that date might be a little bit tight, potentially, because I'm mindful of the need possibly to wait a few weeks for a site visit until weather conditions improve. But I'm saying that without having had the benefit of our witnesses and Nature Scott's witnesses. I don't think I've discussed dates yet. But even if it is the case that the site visit can't take place until later this month or early next month, it doesn't leave a huge amount of time for that to take place. The feedback to happen from that meeting and a statement of agreed matters to be negotiated back and forward between myself and Mr. Ferguson. So,
but on the policy matters, do you think that leaving aside peatland impact and any related guidance, separately the policy matters the 10th of April, does that provide any problems? Because once we start to push things further back, it does actually suggest that certainly the June dates would have been really pushing it. Does the April? Sorry, on you go.
Sorry, so the April date would be achievable from our point of view, from the policy statement of agreed matters. It does fall during the Easter holidays, but we will work around that and have it ready probably in advance of that week in reality. So I don't see an issue with that date. I think the only slight note of concern in relation to the other matter is just the timing of a site visit.
And from the council's point of view, in terms of participating in agreeing a statement of agreed matters, does the April date provide problems for you?
That should be fine.
Okay. And
assuming an early. So I was going to add, assuming the important thing is it's not left to the last moment. But yeah, but I'm sure we'll cooperate well with the applicants, agents on that.
Nature Scott's point of view in terms of the peatland impact matters, leaving aside policy considerations, does the April the 10th date sound reasonable or too early with regard to getting to the position?
For the non-peatland issues,
No, for the peatland matters. I think I have agreement with the council and the applicant, who I would imagine would be the main contributors, but not the only contributors to the policy matters in a statement of agreement. But just dealing with peatland impact and the need for a joint site inspection between the two parties and such like. Does the April 10th sound reasonable, or
it really depends on the dates agreed by the experts for the joint site visits. The experts have now been put in direct contact with each other so that they can arrange that as quickly as possible. But I would share Mr. Gillis's comments that if the statements of agreed matters will largely depend on the site visit, so that's going to be the potential blockage. But I'm sure the experts will schedule that as soon as their calendars allow.
And you don't have any further update on availability? We did discuss whether or not beginning of July would be possible, but it was perhaps an impossible ask in that 10 minutes.
We did try to reach Karen Rentoul, but she is currently unavailable. So as things stand, I could only commit to the dates I've already outlined.
Okay. Thank you for that, and thank you for tying that up, Mr. Finlay.
Yes, so just to say that the first 2 weeks in July the council has availability issues in the first 2 weeks of July, although we're not a major player, but just to indicate that there'd be a preference from the council for the dates, the later dates in July.
Okay. In setting out these dates, I've not had any regard to school holidays or timetables or anything. These were simply based on the timetable. So please flag up any issues. So we're generally happy with a statement of agreed matters on the 10th, but there may have to be a further discussion or pushing back of the statement of agreed matters on peatland impact specifically. But I think if we go roughly with the 10th just now, and again I'll clarify all of this in my note. If there is anything, and I think I highlighted earlier on, if there's anything I want to ask on policy, I would do that after the 10th of April. So there'll be a further round of further written submissions, and hopefully we can conclude that by mid-May. So if there was anything coming out of the statement agreement that I wanted to ask questions on, then I would have a further round of further written submissions. But that should be concluded by the middle of May. So hopefully that doesn't give any difficulty. Dealing with the main session, working back from an inquiry on the 2 days, 26, 27, I have, on the basis of a statement of agreed matters being prepared on the 10th of April, allowing a week for some exchange of views to agree the scope for the inquiry. So allowing a week for that, and then allowing almost 2 months for the preparation of inquiry reports. So inquiry reports I've put down just now for June the 12th, and that's only 6 weeks away from the inquiry, and precognitions by the end of June, by the 26th of June. Does that sequence seem reasonably logical to the parties? That would be mainly Nature Scott and the applicant, to get the scope of the inquiry agreed following the statement of agreed matters, middle of April, inquiry reports 12th of June, and precognitions the 26th of June, and then allowing a period of a month before the inquiry. Does that sound reasonable, applicant, first of all?
Yes, sir, it does sound reasonable, thank you.
And from Nature Scott's point of view?
Yes, sir, that works for Nature Scots.
Okay. Given that the 26th and 27th are, what dates were we talking about? We weren't talking the 26th and 27th, were we? In July, it was
27th, 28th.
27, 28. I'd flagged up that there's not obviously an opportunity to go for a site visit on the day before because 27th is a Monday, and I think what we agreed was that site inspection was to be agreed, and I think I did also hear the applicant indicating that after the inquiry might be difficult for their expert because they have to go away. So I just wondered if it was useful to try and pencil in a site inspection just now. If it could be on the 29th, that would be fine. If it has to be before, then it would have to be the week before. So I would quite like to try and at least pencil in an accompanied a site inspection on Peatland just now. So from the applicant's point of view, given that if we were to have oral procedure on internal inquiry on 27 and 28, Monday, Tuesday, then we're looking at the Wednesday or the week before for a site inspection.
Yes, sir. I think penciling in on the 29th should be okay. I am just conferring with my colleague Lizzie, but I think our unavailability on the 29th is actually Miss Tainsh's instructing solicitor is not available on the 30th or the 31st of that week. Of course, she doesn't and probably wouldn't be at the accompanied site visit in any event. So I don't think that's a barrier to the site visit being fixed, penciled in on Wednesday the 29th. Ms. Tainsh can let me know if she has information about our witnesses' availability that would suggest otherwise, but I think that is okay for us, for our team.
Mr. Ferguson, I think you perhaps indicated it might be useful to do it in advance, but is the Wednesday the 29th, you content that we pencil that in for the site inspection?
Yes, sir. That it makes sense. If we're starting on the Monday, then it makes sense to have the site visit on the Wednesday.
I think it's good just to pencil it in just now so that we can plan for that. So broad agreement there with the dates for the oral procedure. In terms of planning conditions, I would be asking the applicant to have a first draft around to the main parties around about the 27th of March, and hopefully have a final statement on conditions by the end of May. Now, that may not be achievable with regard to certain conditions, perhaps around peatland impacts, but I would like those matters to at least be in the diary for as early as we can, because often these matters drift on a little bit. So, first of all, to the applicant, are you content that going out to parties at the end of March on conditions sounds reasonable, and by the end of May to have concluded the position on conditions as far as all the parties are concerned? I know that is a little bit in advance of the oral proceedings, but I do recognise that these things have a tendency to drift on a little bit. So the applicant, first of all, your thoughts.
Yeah, thank you, sir. Yes, no, we're more than comfortable with that suggested timetable, and in fact, we should be in a position to circulate a draft set of conditions well in advance of that date. And I do, given what we've said about the need to make or desire to make progress with this case, sir, then we were gearing up to progress this matter as quickly as possible in any event. So we should be comfortably able to meet that deadline, and I suspect we'll circulate a draft in advance of the 27th of March.
Thank you for that. I mean, what I've outlined there would allow a virtual, if you like, hearing to take place at a date to be agreed if required in June sometime. So that was the logic, if you like, for having that concluded fairly early. That's if that's required. If it's only further written submissions that's required, then hopefully that can all be concluded by the end of June. So that was the logic for having a slightly earlier timetable. From the council's point of view, initial draft end of March or earlier, and a concluded position by the end of May. Does that sound reasonable?
That should be fine, yes. Thank you.
And from Nature Scott's point of view, or the Community Council's point of view, are these dates reasonable as far as you're concerned?
Yes, sir.
Yes.
Yeah, okay. On the matter of documents, I would hope that the foundation documents, everything to do with the application and all the policy documents that are out there that are going to be referred to, so those foundation documents that are referred to in our guidance note, I would hope that the applicant would be in a position to finalise that by the 20th of March. And I think you've had the draft foundation documents from our case officer. So I'm putting a marker just now down for the 20th of March to draw a line under those foundation documents. And I'll explain a little bit more about foundation documents in my note. I'll not bore you with that just now. Does that sound reasonable from the applicant's point of view to kind of consolidate what the foundation documents are going to be for the inquiry around about the 20th
Yes.
of March? And
That is absolutely fine.
then we would we'll draw a line under that list, and then any supporting documents that comes out of the work of the inquiry, I've put a time on the 26th of June, so essentially a month before the inquiry on Peatland, for all the supporting documents to be listed and that then closed. I'm not anticipating any late documents after that. Does that seem reasonable? And that ties in with the submission of the precognitions.
So that's fine from the applicant's point of view. Thank you.
Yeah. Nature Scott, does that sound reasonable?
It does.
And everyone else happy with these dates about documents? In terms of publishing the additional information, which we've agreed can, in this instance, run in parallel. I think you indicated, the applicant indicated the end of March. So you'd be looking at April for the consultation and my request for further written submissions from SEPA and the council on that, and the opportunity for the council, for the applicant to respond. Would anticipate that will be completely concluded by the end of June, if not by the end of May. So publishing the AI, consulting, and any further written submissions would be all concluded by the end of June. Again, from the applicant's point of view, does that fit with the scheduling you had anticipated?
It does, sir, yes, thank you.
Any other party got any concerns about that sort of for AI? Okay. We'll obviously discuss at the inquiry the dates for closing submissions, but given the nature and fairly discreet nature of the inquiry, we'd be hoping that closing submissions would be fairly swift after the inquiry. We will agree them at the inquiry, but does the principle of having fairly swift further closing submissions, is that acceptable to the parties, applicant?
Yes, so that is acceptable, thank you.
And Nature Scott?
Yes, sir.
Yep. Now, our broad target to report to ministers on this case is actually the 12th of August, and you can tell from even on a fairly limited scope, it's going to be challenging to report back on that date, but we'll get through some of the procedures well in advance of that date. So I think it's useful just to flag up just now, given the timing of it, it may be difficult to achieve that, but I think we should be looking at submitting a report to ministers by the end of September at the very latest, I think, based on what we've agreed today. So useful to flag that up as well. Do you think that is all we need to talk about in terms of the timing of all the events and the documents? You're happy that we could that I've kind of mapped those out for you, and I'll clarify them on my note. Yeah. Okay, that's useful. I think we've discussed site inspection. So item 9, we've agreed on a company's site inspection specifically for peatland impact. There will be other site inspections carried out unaccompanied, both in terms of familiarisation, but also going to some of the kind of viewpoints and to assess landscape and visual matters. But those will be done independently. Item 10 is just simply to point out who the contact is. You've been in contact with Chris. Any matters with the case as far as we're concerned, and if you get in touch with Chris Kennedy. I think I've indicated earlier on that I'll prepare the note for this meeting. I think I gave myself a target of next Friday for it to be issued, and we hope to achieve that. So I'm sure you'll all be waiting for that with bated breath. And just remember that will initiate the first round of the further written submissions. So please don't file it away somewhere. Have a look at it just in case I'm asking someone a question. The last matter, item 11, was other relevant matters. No one said they're going to raise anything, so hopefully that's still the case. I was going to raise 2 matters. The first matter is just to flag up the position that the DPA is in at the moment with regard to strains on our resources across casework teams and reporters. There's an unusually high workload. I'm sure you're all feeling it. I think we have 5 times the normal number of cases in with us at the moment. So we're needing to be reasonably flexible and innovative in how we deal with things. The consequence for this case is that it may well be that another reporter is appointed jointly at some point to assist. It may be the case that another reporter is appointed to take over completely. Just flagging that up, that in order to progress cases, it may not be the case that a reporter who initiates a case is going to be on their own, or the reporter who is on the case for the full duration. And that's simply because of the range of work that we have at the moment, and work that we know is likely to come to us in terms of inquiry. So I'll appreciate if you can just bear with us on that front, particularly with regard to the casework team, in terms of the time that they may have to take to respond to some requests, is because we've got an enormous workload at the moment, as I'm sure we all do. But we will try our best to progress the cases, and the fact that we've agreed a broad timetable today should assist in the appropriate resources being put in place to progress this particular case. If there's any issues with that, I would flag that up in my note. So do any of the parties have anything to respond to that, or is that all fairly clear? Everyone quite happy with that? So if you did see another reporter being appointed, it's probably because we're having to shift resource around the cases in order that we get through them. So thank you for your understanding there. The other matter is something that I would propose to be part of my questions that go out in further written submissions. There's a recent judgment from Rachel Farms Limited against Scottish Government. I think it was this week on the 17th of February. It was issued. The judgment was issued, and it concerns whether a wind farm and associated grid connection, in particular, would constitute a single project which requires environmental impact assessment. It's a very recent judgment. Some of you may have knowledge of it. And given that the judgment has just appeared, I think it's appropriate that you're given the opportunity to highlight any implications it may have for this project. I'm not aware of any particular view that Scottish Government have come to on that particular judgment. That remains, I'm sure, a matter for discussion. But I think, given the timing of it and the potential relevance, I think it should form part of a question on further written submissions, and I will highlight or direct you to the judgment in my further written submissions. Does anyone have any point on that matter they would want to raise, without going into too much detail on the case? Everyone happy that I ask a question on the implications for this case?
Yes, sir. Sorry, yes. I agree that it is appropriate that you're addressed on the implications of that case, that judgment for this case. So I think I would ask if there is a written submission exchange process that the applicant be allowed the last word on any submissions from other parties as to what this decision means for this present case.
Take that on board. Mr. Finlay.
Yes, I have no objection. Obviously, the applicant should have the last word on the point, but firstly, I would suggest that it would be useful to have a fairly short timetable for such submissions, just in case the case isn't going to go any further in the immediate future. Yeah, it may do, it may not. And secondly, it may be worth the applicant setting out its position first, because the parties can make submissions on the general application of the law, but if the applicant were to make its submissions first as to how it sees any potential way forward, then the council could respond appropriately to that, then leaving the applicant with the last word. That's just my suggestion, rather than having an immediate exchange, because my understanding is that there isn't the environmental impact assessment doesn't include the grid connection in this case, and there may be various options open to the applicant how it wishes to respond to that and deal with that. But in order to make sense of the submissions for you, it would be useful to have at least an initial view from the applicant first, to which the Highland Council could respond, and then the applicant had the last word.
I'll perhaps come back to the applicant on that. Does that suggestion from Mr. Finlay to offer you the opportunity to set out your position and then have a final opportunity, does that sound reasonable to you?
It does, sir. It is a very recent decision, and the applicant is still digesting the implications of it, so I would only ask that we are given perhaps more than a week or two, subject to Mr. Finlay's point about the need to make progress. I think we will need some time to consider our position here in relation to this particular application.
Before I come back to Mr. Finlay, does the Community Council or Nature Scott have any comment on that? I'm sure, Ms. Thurston, you might not be versed on this judgment that has just come out this week. But is there any comments from either of you?
From a Community Council point of view, just purely that it's something that we have to deal with ongoing, is split piecemeal applications. So we're sometimes considering a connection application before the actual scheme has been given consent. So it's quite disjointed. So it's an interesting something to come up. It's an interesting development, shall we say? Because it is something that we are, we've spoke with many community councils in the Highland region, and it is something that they all have an issue with, that they are looked at separately. It can be really difficult to consider them They should be, we feel that they should be considered as one.
And from that, would you be suggesting that he would wish to be given the opportunity to comment as part of the further written submissions?
Yeah, I mean, I'll have to take this back to the members, but I think given this development, yes, that would be something we would consider.
And Mr. Ferguson, anything from Nature Scott?
If Nature Scott is requested to comment, then I'll take that back to the team and consider it's not something I specifically considered in preparing for today's meeting. But we wouldn't have any particular issue regarding the sequence of comments. However, the sequence indicated by Mr. Finlay does make sense.
Okay, so I think we've agreed there that we allow that applicant to consider matters and just set out an initial response of the implications, other parties the opportunity to respond, and then the applicant a final opportunity. I don't think that chimes with Mr. Finlay's suggestion that we should do this quickly with regard to the timing of discussions and thoughts on what the judgment means and any further action that may be taken. But that's completely out with our sort of remit as far as this case is concerned. So I would be quite happy to allow the applicant a period of time, a little bit longer than 2 weeks, I think was what was suggesting. If matters change during that time and things become clearer in any respect, then we can deal with it. But at this moment in time, that judgment has been made, and it has potential implications for applications like this application. And I think, until reporting back to ministers and applicants, to consider their position, I think it's important that I do deal with it as part of the inquiry. So if everyone's content with that, I think that's probably all we need to discuss today, unless there was any other matters that any of the parties were keen to flag up. I see Mr. Finlay shaking his head. Ms. Ferguson, from the point of view of the Community Council?
No, covered everything, thank you.
Mr. Ferguson, from Nature Scott?
Nope, nothing further.
And from the applicant, anything further?
Nothing further, sir, thank you.
Okay, well, thank you very much for your patience this morning. I will try and put that note together and get it issued at the end of next week, and then that will kickstart the process.